Good afternoon, everyone. It's very nice to see all of you here today. Today, I will be joined by my colleague Daniel here to go through some basic of H-1B filing. But on top of that, we will also mention a little bit about the 100,000 payment that was just announced like 2 weeks ago. We will mention a little bit about it. I'm sure that you guys all have question about that. Okay, so I will let Dan start, and then I will end the last part. And well, I forgot to introduce myself. Myself is Jiwei Huang Ma. I know that some of you, we have some email or even have meeting together. I'm the Associate Director for Faculty and Scholars supporting ISSS. So just welcome and then happy to see all of you here. Okay, Dan.
Thank you, Chiwei. Yep. So if you don't already know, my name is Daniel Deck, and I'm an advisor with ISSS, and I work primarily with Chiwei on just mostly H's. So we're gonna start to look at that, and we will get to the $100,000 potential payment at some point. Chiwei, do you have the presentation? Yep, there we go. All right. So, so then we're just going to start with the overview of hiring the H-1B employees here at Penn. So let's get started with that. Next slide. All right. So let's go over some of the basic concepts. So what is an H-1B worker? So it's defined as an alien who is coming temporarily to the United States to perform services in a specialty occupation. So let's take a look at and break that down a little bit. So what is a specialty occupation? So it requires a couple of things. So first, it will require a minimum of a bachelor's degree in a specific academic field, and it has to have a direct and logical connection to the position and the position requirements. In addition to that, any licensing and or certification that's required for the position, like a medical license, dental license, something like that, is required for employment at the time of filing. It can't be obtained later on after the H has been submitted. The candidate must also meet the minimum requirements of the position itself when filed. So for example, if you have an individual for a postdoctoral position, that would require a PhD. That cannot be obtained while, or cannot be submitted while the beneficiary is still finishing up his or her PhD, even if, for example, his dissertation or his or her dissertation's been defended, we still need the official transcript and the diploma showing that that individual does have those requirements or does meet those requirements. Next slide, please. Dependents are permitted on H-1B status. They're H-4 status. They can be spouses or children. They typically do not have employment authorization directly attached to that status. However, they can apply for employment authorization if the H-1B beneficiary is in certain stages of the green card process. Other than that, work is not authorized. The H-4 is a personal application, so we at ISSS really only help to submit the documents that have been given to us by the applicants or the beneficiary themselves. We don't really review it because of, it's just we don't sponsor that. I know that I'm always asking extra questions about dependents, because a lot of times I just want to make sure that if there are any dependents, the petition and the application are filed concurrently to avoid any potential gaps in status. Next slide, please. So H-1B, the basics, again, it's a specific position. So it's specific to a job, employer, and location. So anything outside of that is not permitted without extra authorization. The total amount of time permitted on H-1B normally without undergoing certain stages of a green card process is 6 years. We can only request 3 years at a time maximum for H-1B petition. H-1B is nice because it allows for dual intent, unlike other statuses like F or J, where they are non-immigrant. H-1Bs do allow for both green card processing and non-green card processing. And all petitions within the university system must go through us at ISSS. And then, of course, we build them and we submit them to USCIS for their adjudication. That's where we get our notices and approvals and stuff like that. Next slide. So when we're filing for H's, there's really two basic ways of obtaining H status. One is consular, which we can discuss a little bit later with regards to the fee. So we'll definitely revisit that. And the other is the change of status, which is when you have the beneficiary within the United States changing whatever status they are presently on into H-1B status. So the way I always describe this to, for example, a beneficiary is asking me how that works. I always say, well, you go to bed one night in your current status and you wake up the next day in H-1B. So there's really no travel or anything like that required. Next slide, please. So those are the two initial kind of petitions. So the consular processing and change of status. Other types of petitions would be the extension. So if a petition is coming to its expiration date, we can obviously extend that so long as if it's within the 6 years or there's an approved I-140, which is the green card process. An amendment, which is also required for any material changes. So for example, if you have an individual going from a instructor position to a tenure assistant professor track position, that would be a material change. Or adding a bunch of work sites, those would be material changes. And this must be filed in advance of those changes being permitted to take place. Also, there's the portability, which is the change of employer. So obviously an employee moving from another institution into Penn would be a port, and then concurrent employment, which is when you have an individual sponsored with H-1B at one entity and would like to have a concurrent employment, so employment at the same time at Penn in some capacity. So those are other types of petitions that we do file. So as a hiring department, what are the responsibilities? So obviously conducting the hiring procedures, recruitment, job specifications, job duties, stuff like that, and ensuring that the specific degree is required for the position and the candidate has that degree and experience. Once that candidate is, screened, hired, offered a position, setting a reasonable start date is also really important. So for example, today is Tuesday. If you were to say, hey, can you start Monday? We cannot process an H-1B in less than a week. Our normal processing time is about 3 to 4 months. We can, under certain circumstances, get that done much more quickly, but that is a kind of standard processing time that we look at. So we have you submit a complete H-1B request to our office. Typically, we would love 6 months in advance. We know that's not always possible, but 6 months is great because we cannot apply for an H any sooner than that. And then, of course, giving us at least 90 days would be also ideal. Applications with a start date less than 60 days are subject to a rush fee. And we also request as part of the submission that we get a complete and thorough position description that outline the specific duties and responsibilities that that individual and that position are required for. The more details you can give us, the better, because we do need to have some submissions to the Department of Labor explaining what this position requires, what this person will be doing, where they'll be doing it. And so the more details we can get, the easier it is for us to make that submission to the Department of Labor. Next slide, please. Once we get those submissions, it's going to go to our office. It's going to be triaged and assigned to an advisor. Once we get it, so for example, if it's coming to me, I'm going to take a look at that case. It takes me some time depending on what we're working with, the details of the case and stuff like that. But I do send out an email, and all the advisors send out an email basically saying I have the case. And then, of course, we have a lot of questions to begin with. such as for me, I always ask about immigration proceedings, dependents, work sites, for extra documentation, and things like that. So any questions that we kind of see initially, like this will really help us move the case along, we're going to reach out at that time for that information. Next slide, please. And what we do with all of that is we do the wage analysis. And this is where those details really come into play with the position descriptions. So basically, we need to look at what the position is, what those duties are, and find what's called a SOC code. And then we take all that and we make the determination on the prevailing wage, which is the minimum amount that Department of Labor says this individual should earn as a salary. Typically, we don't have any issues with this, but when we do, we try to work with you on seeing what can be done to work all any issues that may come our way. Once we submit our submission, the LCAs take about 1 week for certification from Department of Labor. So that does kind of slow the process down sometimes. In the meantime, we're working on other things in the background. It does mention here that we can submit a prevailing wage determination from the Department of Labor, but the problem is they take so long to do that we run out of time before they're ever made by the Department of Labor. So I don't think I've done this in a long, long, long time. And then, of course, the other thing is the actual wage is the comparison of similarly situated individuals in that same position to make sure that no individual is being paid exceedingly more or exceedingly less than the others. So it's kind of like a fairness within worksite. Next slide, please. So as I mentioned, the LCA, the labor conditions application, goes to the Department of Labor. It takes about 7 days for its certification. And once it's certified, then we're able to take the certification and kind of work on the rest of the case, build it, look at the arguments we want to make, and put the full petition together. Once that's good, we put it in our internal processing for review by our peers here at ISSS. Once we get the all good with that, we can submit it to USCIS. There's the regular versus premium processing, which I'm sure most of you are aware of. Regular processing fluctuates wildly. It says 2 to 9 months. I think that's quite accurate. So depending on what the current processing times are at USCIS, you may be able to use regular processing, but it's subject to change. Whereas premium, it is more expensive, but we do get an answer within 15 business days from USCIS. So that does help secure things. It also provides us with an e-receipt once USCIS receives it, which allows us to get the receipt number. So in case there is an issue with the case for whatever reason, we're able to track it down at USCIS. And that's another benefit of having the premium processing. Next slide, please. So approval or request for evidence. Request for evidence, we've seen more of these lately, and they do require response. They can be very simple to respond to, which is great, but sometimes they are very, very lengthy and detailed, and it takes us quite some time to build a case, review documents, and stuff like that. We communicate that information to you, as well as the beneficiary for any evidence we may need in order to respond appropriately. Once an approval is received, it is sent to our office. We notify the department, the employee, and provide a digital copy of that. And then that hard copy should be either picked up by the department or the beneficiary to complete any other I-9 or departmental reporting that they must undertake. Next slide, please. So when can the employee begin? So if that individual is not an H-1B status, we highly, highly, highly recommend that they do not start until that approval notice arrives and is current. The reason for that is, and I actually had not a bad situation happen, but because the individual, it was consular processing out of the United States, but I requested, I believe, a start date of in July, and USCIS gave this individual a start date in September. So had that individual been within the United States and started working in July, but got a September start date, there would have been some employment issues with I-9 and unlawful employment. So that's why we always recommend starting, even if we get that approval online, we wait for the actual hard copy to arrive. Overseas, the individual can start once they're they come to the US, they're in H-1B status and the state is current. Now, if they already have H-1B status, and they have an extension, a port, or an amendment, once that petition is received, they can continue or start their employment. An approval notice is not required for them to start that. Next slide, please. Once they've got H-1B status, there's ongoing responsibilities. So any changes to the approved employment, as we mentioned earlier, for example, like I think I said, going from an instructor to a tenure track professor position, that would warrant an amendment, and that needs to happen before the change takes place. There's also verification that happens every 6 months. And then, of course, if the job title, degree required, hours worked, really any material change should be reported, or any change in the position at all should really be, we should really be informed of that so that we can properly maintain the records and advise accordingly. In the case that there's a termination or employee resignation, we obviously need to be made aware as well. There's e-forms for that. You can always email us and ask for advice on how, best to proceed with that, and we'll obviously help you through that. And then, of course, any expiration dates that you're aware of 6 to 7 months in advance, you can let us know, and that's a great time because we can start vetting the position and get a timely filing with USCIS. To revisit the termination and resignation, as I previously mentioned, it's great to always consult with us prior to the termination of employment of a foreign national. So we can advise, we can work with you on anything that may need to be documented or make you informed of anything. And then, of course, sending a copy of the resignation and termination notice to us in advance. In the case there's voluntary resignations, we should also be informed, and then the end of employment e-form and IPEN should be utilized to report that to us. Next slide, please. The filing fees. Previously, we were using checks to file for all our H-1Bs, but as of July 1st this year, we began using Form G1450 to pay for the fees. It's gone really smoothly, which is great. And basically what we do is we kind of front the money with our Pro card, and then we use that budget code that was submitted in the e-form, and we bill the departments at the end of the month in which the petition was submitted. So we have a report where we send, and that's where you're gonna see that money come out of the business office. Okay. So now we get to the slide probably most of you have been waiting for, the presidential proclamation that occurred on the 19th, stating that a new fee of $100,000 will apply to new H-1B petitions either filed on or after September 21st. As far as we can tell, the 100,000 does not apply to petitions filed before that deadline, already approved petitions, individuals who already hold H status and they're okay traveling, and now all the other non-immigrant statuses, so FJ, O, TN, E3, so on and so forth. We are looking at the change of status filed within the US. We believe it should not be impacted at the time of filing, but what we are unsure of is this may come into play if and when that individual travels home and seeks the H-1B visa stamp in their passport. It's unclear at this moment. And it's also unclear how this fee will be collected, processed, what kind of evidence will be used to show that it was paid, if it was. We're very unclear about that at this time. So what we're doing right now is for those individuals who remain in the US, they can continue working, they can extend their status. And for all the new filings, we're coordinating with departments and internally and with our outside counsel to ensure that we're getting everything done as properly as we can for the moment. Yeah. Next slide. Okay, Chiwei, this is you.
Okay. So now I'm going to talk about options other than H-1Bs. So if you have any questions, just please feel free to write on the chat box, and then we will answer question at the end of our presentation. Okay, so in order for people or for international scholars or faculty members or researchers to work for you, well, H-1B is the most common visa or status, but there are other options. If H-1B, for example, has reached 6 years, or H-1B, or this person is subject to 212E because this person was on J before, or this person is from any, like Australia, for example, or from Mexico or Canada, they have other options. They have options other than H-1B. Okay, so the first one is STEM OPT or OPT. This is for people who are on a F1 visa right after their graduation. They can actually enjoy OPT for a year, or a STEM OPT for another 2 years. Okay, and our TN, just like what I've mentioned, this is especially for Canada, Canadian or Mexicans. E3 is for Australian. And then, of course, there are B1, B2. If they are only here for a short period of time and give a talk or something, it's fine for you guys to give them honorarium, okay, or try to give them reimbursement of the traveling. O1 has a much higher bar than H-1B, but this could be one of the options for some people. And then the final one is permanent residency. Okay. So let's start with OPT. So OPT is called optional practical training. That's for people who receive their education here in the United States. Okay, so right after graduation, they have this 12 months of OPT. And if this person is having a STEM major, then they should be able to enjoy another 24 months after the regular OPT. So that's called STEM OPT. And STEM OPT is a little bit more, has a more requirement from the government. And then, and department, if you are hiring a STEM OPT person, they may want you to help them complete this called I-983 training plan. It's not very difficult to complete, but then you just want to make sure that everything you write for them reflect the facts. Okay, so this is STEM OPT. So this is a regular OPT card. If a person, a scholar or a student, a graduate student or something come to you and said, well, this is my EAD card, so I'm allowed to start working. And then, well, as you can see, the start date is here, January 1st. And that, well, this is not a very logical start and end day. But anyway, on the EAD card, you will see the start and end day. So you just want to make sure that this person does not start working for your department before the start day on the EAD card. And they can now work for your department after the end day. Okay, so this is basically, and we just want to be very careful because sometimes onboarding, they may miss something. So when they try to work for us, for your department, you want to make sure that you watch it very carefully. STEM OPT is the 24-month, like granted to people who are in STEM major. So it's up to 24 additional months. And then, like I said, that you guys have to help them complete this I-983 training plan. And the student, both OPT and STEM OPT are not sponsored by UPenn. They are sponsored by the student's school. Okay. For example, if this student was graduated from Drexel, then Drexel will be their sponsor for their OPT and STEM OPT. Next one is TN. TN is for citizens of Canada and Mexico. Okay, so these professionals, like there is a list of TN perfection. Okay, so this is on our website. There are lists of perfections. They are qualified under TN regulation. So Canadian citizens, they do not need to go for a TN visa interview. Once they get their TN, they can just cross the border. Okay, they do not need to have a visa interview, and they do not even need to come in with a visa as long as they have the TN status. Mexican citizens, on the other hand, they do need to go for a TN visa interview. So for Mexican citizens, it's much more complicated than people who has a Canadian passport. So TN reason in the past, well, perhaps like many years ago, our department, our office does not really help with TN, but just starting last year, I believe, we started to help with TN application. It's just that we receive more and more inquiries from the department. And then the process has become, well, it's an easy process, but then sometimes a CBP officer just maybe are not very familiar with the process. So sometimes department calls or CBP officer call us. So we are hoping that after we offer our assistance to the department, everything will become much more smooth. Okay. Next thing is E3. We do not get too many E3, but it's come out occasionally. So B3 is for Australian citizens. Okay, so it's basically the initial work authorization. They give you 2 years, and then this could be extended indefinitely. And then E3, they have very similar qualification as H-1B. This position needs to be a specialty occupation, just like Dan mentioned for H-1B. For E3, the job also need to be qualified for special occupation. And we also have to file labor condition application. Whereas TN, we do not need to do that. Okay. So this is E3. Next one is B1, B2, which I think is especially important because I know that some department would like to hire or invite. I shouldn't use hire. I take back that hire, because hire means that we have an employment relationship with this person who is coming. But then B1, B2, we cannot have employer-employee relationship with the person that is coming to visit Penn or just come here for a conference or give a talk. Okay, so B1, B2, as we do not sponsor them. Okay, it's a personal visa. Okay, and the purpose, just like what I mentioned, this is not employment, employment relationship. This is not a work visa. So they cannot receive salary from us. They cannot receive compensation from us, but they may receive honorarium from us as long as they stay at Penn no longer than 9 days. And they did not or have not received honorarium from more than 5 institutions in the past 6 months in the United States. So this is a very, very important information that department need to know, especially if some of you are planning to invite someone to campus. Okay. Next one is O1. Okay. O1 has much higher bar than H-1B, and then it's also much more expensive to obtain an O1 visa. I'm saying much expensive is that, well, our office does not process O1. So if your department is willing or is planning to sponsor an O1, this O1, you still need to let us know, and we will forward to our outside legal counselor. Okay. So most of the time when people coming to use O1, that means that, well, this person perhaps is subject to 212EJ waiver, and they haven't received the waiver. Okay, they are subject to 212E home residency requirement, but they haven't received the waiver. Then O1 is a possibility because O1 does not need a waiver to start. Okay, and then also, or this person has used up their H-1B, but they are still waiting for their green card to be approved, then O1 could be an option, could be a transitional visa or status for this person. Okay, but the qualification for O1 is much higher, just like what I've mentioned, than H-1B. So for O1, basically are for people who bear extraordinary abilities. Okay, in science, in art, in education, business, or athletics. Okay, so you want to make sure this person has a record of extraordinary achievement. And then initial stay for O1 is 3 years. And every time we extend it is 1 year. But then the budget that you are looking up to around like 8,400 for the initial O1, that's only for the legal fees. So as you know that it's much more expensive than H-1B, and then it also need much longer period of time. But if there is no other choice for H-1B or other visa type, then O1 could be an option if this person can show an extraordinary achievement. Okay. So this one we want to mention a little bit about our O1, just like what I've mentioned, that O1 and also PR, that we will go through our outside legal counsel. And as you know that we have two outside legal counsel, and then now in the past, we help faculty members, we help department process special handling PR, but now we also hand over. We will also forward faculty cases to a law firm that you select, because that we find out that, well, some people, a lot of faculty, they are qualified for EB1, and some of them are also qualified for NIW. So special handling is also one of the options. So we figure it's for the faculty's best interest, and also for the department's best interest, to give it to the law firm to have a more holistic review and evaluation of the cases. Okay, so for special handling, it's much easier than regular perm EB2, but then it must be a teaching position. Okay, or there must be a teaching component to the job. Okay, and then the law firm will help file a perm labor certification within 18 months of selection. And the preparation time for perm is around 10 to 15 months. Now the Department of Labor, the processing time could take longer. Okay, but special handling comparing to NIW, a national interest waiver, and EB1B, this special handling has need much less evidence than the other type of PR categories. So many of the faculty members or the department, they will use special handling as the basic PR category for them to start with. And here I just want to mention again that at Penn, we normally do not sponsor staff position for PR. We only sponsor research position or faculty position for PR. But if there is a person in your department who is a staff, and then your department really like him or like her, and then you really want to keep her or him for long term, then that's the time that you want to complete this policy 119 exception request. So if you have cases like this, you can reach out to me. We do have a guidance, okay, and a checklist as to how to write up this special request for the 119 exception. Okay, so you need to establish the link between this job and how exceptional this position is. Okay, so once you establish the connection, once you establish the evidence, okay, basically the PI or the hiring supervisor, they need to write up a letter and to show how unique this position is and how unique this person is. And it's really hard to find a second person in Philadelphia area to fill this position. Okay, so this one need to be submitted through IPAN. And then once we have, there is a PR review committee. They will review your request for the reception, for the exception, and then they will make the decision at the end. If they agree, then you will get an approval, and then we will receive the e-form to process PR, then we will pass the PR to a law firm. If they say no, then that's the end. We won't be able to pass it. But if they say, well, we want to ask for more document, that you will also be notified. Okay. Okay, so now I want to introduce a little bit about these two law firms that we use. Number one is Goldblum. Okay, this is a relatively smaller firm, but it's very intimate. Okay, and they are very well, I would say both of the firms, of course, we pick up very good. And then Goldblum is a smaller size, classical as one of the largest in the United States. So it really depends on your preference and see which law firm that you want to go with. Both of them are very good. It's just that depends on personal preference. You like to work with bigger firm, or you like to work with smaller or more intimate firms. Okay, I think we end our presentation.
Oh, of course. Don't worry about it.
Okay. Okay, I think we end our presentation earlier than we expect, but then it's good that so that we can answer some questions. Natalia. Okay, oh, we have a lot of questions. Let me take a look. Okay, first question. If someone is going from OPT to an H-1B, will the 100K fee apply? Then do you want to take it? Oh, okay, then already answered. Okay, so so I think then it's correct that if this person is currently in the United States, we can file a change of status from OPT to H-1B for this person. So we can confirm that to file this change of status H-1B in the United States at this time, you won't be charged. The 100K in the United States won't apply to you. But then if this person, they said that once she or he got H-1B approval and he is planning to travel back to Germany, when he is getting his H-1B visa in Germany and seeking entry into the United States, that's the time that the 100K may apply. Okay, because he is getting a new H-1B visa and this is a new petition. Okay, so if he does not travel, no problem, it's fine. But if he travel, then there may be an issue. Another possibility is that if this person is outside of the United States currently, and we are filing a petition for him, we got approval, we shipped approval to this person outside the United States. When he plan to come in and apply for the H-1B visa, then the 100K will apply. Okay, I hope it's clear enough. Would H-1B be eligible for a J-1 petition, J-1 application? Okay, then basically you answer everything, right?
There's a few other questions that just came in. So like, for example, Natanya wrote, there's an H that'd like to transition to an O while they're waiting for the PR. Could they use their own attorney?
Okay, no. So for O1, they always need to use our attorney. Okay, PR, if it's a self-sponsored PR, then they can use their own attorney. But then sometimes the department may not be clear about what is considered self-sponsored. It's EB1A or NIW. Those are considered self-sponsored. But if you are not clear, please be sure to reach out to us. Okay, reach out to me, because we do not want to see a situation that this person has already worked with her own outside legal counsel, right? And then on EB2, on EB2 perm, for example, then there will be a huge issue because PAN policy does not allow employer sponsor visa to go through an outside counsel other than Penn outside legal counsel. Yeah. So next question is that if a current employee shift from their postdoc position to a faculty role, will they need a new H-1B or will they eligible for the amendment on their current H-1B? Okay. Dan, do you want to answer or you want me to answer?
I mean, it's an amendment. Yeah. I mean,
Yeah.
it's so the term new H-1B that's kind of, I think, where, at least for me, I think for a lot of us, that kind of creates a lot of confusion. But if this individual already holds H-1B status for their postdoc, we would definitely file an amendment for them to switch to a faculty position.
Mm-hmm. Yeah. Okay, very good. If we have a H-1B abroad still waiting for their visa, how should we proceed from here? Okay, so it depends on whether this person has already received an H-1B approval. Natalia, do you want to mention a little bit more about the particular?
Sure. And I'm sure Daniel knows exactly who no.
I know exactly who you're talking
Yeah.
about.
Yeah. I just wanted to know, how should we proceed? Should we close out? Because it was likely they may not come here due to where they're from originally. But now with this 100K fee, how do we proceed? What should we do? That's what I'm curious about.
So, because I know, I mean, I'm going to try to speak in generalities while answering a specific situation. If a petition was filed and approved prior to the 9/21 deadline, they should not be subject to it, especially if they've been undergoing admin processing. So any petition going forward for consular processing where the individual is overseas and requires consular processing, whether or not it goes administrative review, that's a whole nother situation. But anyone who's been waiting prior to that date should not be subject to that fee. Anyone going forward may very well be subject to that fee and most likely will be.
So your answer is continue to wait.
Yes.
Okay,
In
thank you.
that situation,
There's still hope.
yes.
Okay.
Yes.
Okay, thank you.
You're welcome.
Yeah, just to add that any petition got approved or filed before September 21st, the 10,000, not only 10,000, it's $100,000 does not apply to them. As long as the petition is filed or being approved, that 100,000 doesn't apply to them. Okay. So next thing, to switch from instructor to assistant professor. Is this an amendment as well? Then do you want to answer or you want me to? I will let you
can
answer.
Oh, okay. I would say yes. Most likely, especially because and typically I would from my understanding, instructor is non-tenure, whereas assistant professor is tenure. So that's definitely going to be cause for an amendment petition.
Okay. So the judgment call for amendment is that whether this is considered material change to the employment. Okay. So according to our understanding, the instructor and assistant professor seems to be different track. Okay. If the job duty is the same, but because the job title, according to our understanding, the instructor and assistant professor, they are different track. So then we will still recommend an amendment for that. And then very important, please do not that the scholar to start working on a new position before we file the amendment for them. Thank you, Melanie. Is it too early to determine whether grants can be used to pay for the new fee? Like from the immigration perspective, we we will only like find out who is responsible for the fee. Is it does it need to pay by the employee or does it need to be paid by the employer? As for whether grant can be used, I do not see why not. I think a grant could be as long as it's paying grant, right? I think this may be an HR question. But then from our perspective, we just want to find out whether PEN is responsible for it or the employee is responsible for it. And then so far, according to the information that we receive, then the employer is responsible for the fee. Thank you, Nancy. If a newly hired faculty member is currently on F1 status in the United States, would you advise first using the STEM OPT period or beginning the H-1B process right away? Ben, do you want to answer this?
Yeah, I mean, my personal preference is for you to use the STEM if available. But I would also, if it's faculty, you might want to be careful on the track. Like if it's going to be, it kind of relates to the tenure track because of the non-immigrant status of F. So if it is going to be like a tenure track, I would recommend going for H. What do you think, Shiwei?
Good question. Good answer. Yeah, well, faculty member is a little different than regular staff position, because as far as I understand, that many departments, when you guys hire faculty members, most of you have a long-term plan for this person. Maybe you want them to stay, and just like them mentioned, that at the end of the day, you may want to upgrade them to tenure track, right? So, to change status from F1 OPT to PR is not as smooth or as recommendable than change status, adjust status from H-1B to PR. The reason why is that F1 is a non-immigrant status or visa, whereas H-1B is a dual intent visa. So that it is fine for you to change your status from H-1B to PR, or when you go for a visa interview, they ask you, are you planning to stay in the United States for a long term? For your H-1B visa interview, you can say yes. But for F1, it's basically a non-immigrant intern visa. They do not expect you to have long-term plan in the United States. Okay, so it depends on the goal. If for faculty member, I think to change status to H-1B will be a better option if you plan to sponsor this person with PR. But if just like you are not so sure, then maybe OPT is a better option. Okay, thank you.
While we wait for any potential other questions, I did think of something that I forget, a question kind of made me think of this is I've been getting some, I mean, other than the increase about the 100,000 fee, but it kind of relates to this is earlier, still September, right? Yeah, so earlier this month, Department of State did release new guidance that individuals should be obtaining visas in their home country now. So I know this has come up with quite a few H-1B status holders because they have conferences. They're like, oh, I'm a Chinese national, but I have a conference in Germany. Can I get my visa there? And previously we were kind of like, oh, you want to make sure you give enough time to allow for any administrative processing that you may undertake. But now, given that new policy, I know that may cause issues with conferences or any kind of other international travel that would be required or available to the H-1B beneficiary.
Yeah, I just want to be very careful because in the past, people will ask us that, well, I'm a Chinese national, right? And then I'm going to Germany to for a conference. Can I just go to Germany to have my H-1B visa extension request, like go there to renew my H-1B visa? In the past, we would say, hey, you want to contact the local embassy and see whether they would accept their party or their country application. But now we will say no, because the government just passed this guidance that you just have to go back to your home country to get your H-1B visa. Yeah, so not everyone has to go back to their home country. There is no third party or third country applicant available. Yeah. Just a quick advertisement that on Friday afternoon we will have a H-1B check-in only for H-1B employees. So if you have any H-1B employees and they did not receive invitation or something and they have questions about their H-1B status, feel free to have them contact me or Dan. Okay, we can send invitation and more information about this H-1B check-in. And it's also good for them to get together to do some networking. We in the past, we started this checking, in-person checking last year. Am I right then?
Mhm. Yeah, I think so. Yeah.
Yeah, we are just hoping that we can be a center not only to provide immigration policy or update, but we can also give them an opportunity to network with each other. Yeah. And then please just let us know if any of your H-1Bs who are interested, and please just let us know. Well, this applies to new H candidate who will be hired by our department in the beginning of 2026. Okay, so let me answer this question. It depends on where this person will be hired, right? If you want to hire someone outside of the United States and you want to bring them in, then I think it will, for sure. Well, beginning of 2026, I think, well, if the guidance maintain the same, then I will say it will be effective. But if this person is in the United States, then again, only to change status in the United States, then it's fine. But then if this person is traveling abroad to get H-1B visa and return, then it will be impacted. But one thing that I want to mention is that we actually we went to a webinar hosted by our outside legal counsel, and we heard people may initiate litigation against this decision, right? So there is a possibility that a court may impose a preliminary injunction on this guidance or on this executive order, right? So if that happen, then we will know what we entail. If that happen, then the 100,000 fee may be temporarily held. Okay, maybe temporarily held, but then we cannot predict the development, right? So now for beginning of 2026, nobody could predict what would happen, but I can just let you know that if there is a lawsuit, a litigation against this executive order, then maybe the court will impose a preliminary injunction on this, and everything will be paused. Yeah, that's what we know.
Yeah, it's an extremely fluid situation. I mean, we're waiting for a lot of guidance, and I mean, some of the guidance that we may receive could render a lot of our kind of understandings and, readings on this matter. It could change them, and we have to like go back and be like, I know we said this, but now we're changing this. There's a lot of moving parts right now. So, your patience with this and us is much appreciated.
Yeah.
Oh,
So
just to clarify.
Nancy, so you were to clarify a previous question, if an individual seeks H-1B change of status visa outside the United States, when traveling. So are you saying that this person has a change of status petition in the United States, and he or she need to travel to get a new visa to come back?
Yes,
Yeah.
correct.
For this situation, highly possible.
Okay.
Because if this person never has an H-1B visa, he was on another position, like another status, and we just filed this change of status for him or her, and it got approved, and then when he traveled to get this new visa, everything need to happen after September 21st, okay? So if that's the case, it's highly possible that this person will be subject to 100K. But the thing is that nobody know the process, how to even pay the 100K. The government did not really give us guidance. Who is going to take the 100K? Who is going to pay for the 100K? When are we going to pay for the 500K? No detailed procedure was announced. Yeah, that's the issue. Okay, if you guys do not have any further questions, that we are going to we are going to stop sharing anything here. So, and we will see you guys very soon next time. Yeah. Okay. So thank you. Thank you for coming.
Thank you.
Thank you.